There are other issues related to forum selection. One of those is called venue. Venue refers to the geographical location of a proper court to hear the dispute. Now, venue is often confused with jurisdiction, but it's very different. Jurisdiction is the power to hear a case. Venue refers to where should the case be heard? What is the best geographical location to hear the dispute? Venue is something that the parties can agree on. The parties can agree to venue. They cannot agree to jurisdiction. So venue is a matter that you'll hear about occasionally in the law, but is a much less important concept than jurisdiction. Another concept that we need to look at is what's known as forum nonconvenience. And forum nonconvenience is a common law legal doctrine in common law countries wherein a court may refuse to take jurisdiction, even though it has jurisdiction, over matters where there is a more appropriate forum available to the parties. So FNC, forum nonconvenience, gives to a court the power to refuse to hear a case even though it may have personal jurisdiction and subject matter jurisdiction. Now, this is relatively rare, but it often comes up in situations wherein there's the possibility of forum shopping. Forum shopping, you probably have seen it in the news, is that oftentimes we pick a court not because it's appropriate, but because it has jurisdiction and will give to the plaintiff an advantage in the proceeding. Forum nonconvenience was a factor in a number of cases that arose out of an explosion at an Indian Indian chemical refinery in Bhopal, India. Dow Chemical owned, or through a subsidiary of Dow, owned the factory. When the factory exploded, a number of people were killed, a number of people were injured, property damage resulted, and immediately there were plane loads of American plaintiff lawyers flying to sign up clients in Bhopal, India, to bring a claim in the United States against Dow Chemical. So the courts in the United States had personal jurisdiction over Dow because Dow may be doing business in that state. And they had subject matter jurisdiction over the type of injury that occurred. But there was this fear that these cases should really be heard in India. That's where the witnesses are. That's where the evidence is. And in the case of Dow, it was an Indian subsidiary that owned the factory, not the American holding company. So forum nonconvenience was used by the court there to refuse to hear these cases brought by these Indian plaintiffs in the United States. Forum selection clauses, we mentioned this before, the parties have the ability to determine where the case should be heard. The main case on this, a very famous case, again, a Supreme Court case from 1972 and called the Bremen versus Zapata Offshore Company. This case was about the sale of a offshore oil platform that was going to be transported from Louisiana, off the coast of Louisiana, to Italy. And as the oil drilling platform was being moved, there was a hurricane in the Gulf, and the platform was damaged. The platform wound up in Tampa, Florida, and so the defendant in that case, or the plaintiff in that case, the party that had suffered the loss, filed a lawsuit in Florida. Turns out that the contract between the parties actually set out a forum in London. And so the court was faced with this question of where is the proper forum for this dispute? Is it Florida? Is it Louisiana? is it Italy, or should we look to the contract? And in that case, the court supported the contractual forum selection, meaning the dispute had to be heard in London, not in Louisiana where the oil platform was or where it had come to rest, but in the forum that the parties had previously selected in their contract. And the reasoning behind this was this gives predictability of the law, and it ensures neutrality of the legal forum. So when you and I enter into a contract, we can determine that forum in advance. And it may well be that you want one location, I want another location, and we agree to this neutral location. Courts will support whatever the parties agree to. So on your test where this comes up, it'll come up in the situation of where is the case going to be heard, and it's going to be wherever the parties agreed to. Now, there are some exceptions to a forum selection clause if the party who is moving against it can prove that it's unreasonable or unjust, or if it's bad public policy, it's bad for society in general, or there was fraud involved in the contract formation. Those are potential exceptions to enforcing the forum selection clause. But the thing you need to remember is ordinarily these forum selection clauses are enforced.